This Scribble Kibble episode is educational, but it is not legal advice. I thought it would be enough to cover the two most important legal concepts for artists, copyright and fair use, but no, it wasn't enough, so here we are again, ready to learn how to play Trademark, the expensive game. The reason I didn't talk about Trademark before is because it's fairly useless for small artists. You become interested in trademarking things once you're serious enough to register your art business with the government. If that doesn't describe you, then you benefit more from copyright, which automatically protects each work of art you make. Trademark only protects your logo. Technically it protects your brand, but most trademarks are either for a logo or a product name. So don't plan on trademarking a character, because it isn't going to happen, unless the character is a literal part of your logo. So, while I set up my fake board game here, note that this is the United States version. Every country's laws are different, but the purpose of the law is so that a competitor can't show up and use the same name as you, or a similar name, to try and confuse customers into buying their item. It would be very confusing if there were two YouTubes, or a YouTube, or 5 different Disneys that all made animated films. Trademark tries to prevent this from happening. Let's look at the trademark rulebook. First rule, you do not automatically get a trademark just because you used a name once or twice. You have to establish a trademark and constantly use it to keep it. A piece of art you drew, not trademarkable. The name of one of the characters in your book, the unique username you use to sell all of your art under, you might be able to trademark that. Okay, rule number 2. Your trademark only covers your market. If somebody starts manufacturing heavy construction equipment and decides to label it Scribble Kibblers, there's nothing I can do to stop them. I could go after anything entertainment related, videos, comics, art. There has to be a chance for confusion. If your competitor is in a completely different market, your trademark has no legal power over them at all. Usually. Third rule, your trademark is only protected in a set geographical area. If you make and sell Scribble Kibble shoes in Indiana, I could still make and sell Scribble Kibble shoes in Ohio, unless you register and defend your trademark at the national level. But that wouldn't stop me from making and selling Scribble Kibble shoes in Canada. For this reason, companies register their trademark in every single country important to them. It gets expensive and paperwork crammed very fast. 4. Very famous marks like Disney and Skittles have completely different rules applied to them. You will not be able to use very famous names in any trademark, so don't even bother. 5th and final rule, in the United States you do not need to register a trademark with the government to be protected. But people who register their marks win, versus people who don't, most of the time. Okay, so those are the rules, let's play. Who do you want to be? All of these companies are going to try to get their trademark registered. We've got Art Prints, who makes printed artwork. Wonky Comics makes comic books. Tonika Estelle, a pen name used for years to publish fantasy novels. Kiki Rucker Entertainment makes animated movies and toys of the characters in them. Akbud Music makes music. And Stupid Cartoon Wolf makes handmade arts and crafts. So pick your player, because not everybody's gonna make it to the finish line. Alright, first move, the name uniqueness square. You have to prove your name can even be trademarked to begin with. You can move on to the next square if your name is one of the following. Fanciful, it's a made-up word. Arbitrary has nothing to do with your product. Suggestive, which means it describes the product but in a creative way. Or established, meaning you've been using it in the market for a long time and there isn't anyone else using that same name, so there's no confusion. You don't get to move to the next square if your name is generic. So Art Prints, your name describes your product. Art Prints is exactly what you're selling. You lose! Be more original next time. Add a creative word like Zing Zang Art Prints. So if you've made it to square 2, now you get to roll the dice, because there's a high chance somebody's already using the name you thought was original, even if you made up a word. So if you don't roll an 8 or higher, I'll make up some reason you can't register. Wonky Comics. Turns out there's a Wonky Graphic Novels, spelled with an IE, registered at the USPTO. You lose. There's no fighting that. You cannot register a trademark if somebody has a registration at the USPTO that sounds similar or looks similar to your name. It does not need to be an exact copy of your name. Akbud Music. You type Akbud into Google and get 2 million results. Akbud was a word you made up, but it turns out some random company thought of it first. Even if you could trademark your name in a different market, you don't want to live your life under their internet shadow. Go back to square one and come up with a new name. Stupid Cartoon Wolf. Oh, you're right on the edge. You type your name into Google and find a person who made a Twitter and a Tumblr under the name Stupid Cartoon Wolf, but they're not selling any goods or services. So in this situation, you can register a trademark if the name shows up on a quick internet search, but it's not being used in a way that grants it trademark. So Stupid Cartoon Wolf decides to take a risk that the Twitter user is unlikely to hire a lawyer and sue them now or in the future, and even if they did, that it would be unlikely they would win the case. So keep playing. Money stop! It's the reverse Go in Monopoly. Everybody pays at least $250 to start the application process. Kiki Rucker, you want to sell animations and toys, so you need to apply for 2 trademarks. That'll be $500, please. Tonika Estelle, you've got money saved up from publishing all those books. Trademarking a pen name is extremely difficult, and you know this, so you hire a lawyer to deal with your application. Great, you registered. Now you have to wait at least 8 months, and the whole time argue either with the USPTO about why you deserve the mark, or fend off people who come out of the shadows to file a counterclaim against your pending registration. So draw a chance card. Tonika Estelle, office action. That means the USPTO comes along and says, hey, you filed this trademark, but guess what? You can't trademark the name of a person. You hired a lawyer. Your lawyer responds to the office action and is able to prove that you had long and exclusive use of the name Tonika Estelle in the literature market. The USPTO accepts the argument, and you're free. Kiki Rucker, lucky duck, nothing. Your name is so unique there's nothing else like it. You filed your applications correctly, did all of the paperwork the USPTO asked for on time, everything's done, you're set to go. Stupid Cartoon Wolf. Oh, another office action. Hey, you get a letter from the USPTO. Turns out a jewelry company named Stupid Cartoon Lobo is already registered. Lobo in Spanish means wolf. Well, you didn't hire a lawyer and you're not sure how or even if you can argue back with this, so you lose. Back to square one for you. $250 poorer. And if you make it through all that, you come out a winner and you get to use your registered trademark. Yeah! So we've got 2 winners. In the United States, Kiki Rucker can make animations and toys without worry of competitors stealing their name, and Tonika Estelle can keep publishing fantasy books without worrying someone else is going to use the same name to publish knockoff books. Now, people can still infringe, but you can easily destroy them if you have a registered mark. Unless the infringer can prove that they established the same trademark and have been using it since before you did. But other than that, there you have it. That's the simplified version of how to play Trademark in the United States. It's an even more messy battle of money and lawyers than copyright is, so have fun. Try the Copyright and Fair Use episodes to learn to protect yourself from big companies whining about how you used 1 second of their video, and to rescue your original art from dirty, dirty pirates. Stay subscribed for a future tutorial on how to fight fake copyright and trademark claims that you will get if you upload videos on YouTube. If you haven't had one yet, just wait.